true. But it obviously had a meaning. That's why they put it in this important standard. Bribery was not this overarching concept that Chairman Schiff indicated. Quite to the contrary, the original standard was treason and bribery. That led Mason to object that it was too narrow. If bribery could include any time you did anything for personal interest instead of public interest, if you have this overarching definition, that exchange would have been completely useless. The framers didn't disagree with Mason's view that bribery was too narrow. What they disagreed with was when he suggested maladministration to add to the standard, because he wanted it to be broader. And what James Madison said is that that's too broad, that would essentially create what you might call a vote of no confidence in England. It would basically allow Congress to toss out a president that they did not like. But once again, we're all channeling the intent of the framers, and that's always a dangerous thing to do. The only more dangerous spot to stand in is between Congress and an impeachment as an academic. But I would offer instead the words of the framers themselves. You see, in that exchange, they didn't just say bribery was too narrow. They actually gave an example of bribery. And it was nothing like what was described. When the objection was made by Madison, ultimately the framers agreed. And then Morris, who was referred to earlier, did say we need to adopt the standard. But what was left out was what came afterwards. What Morris said is that we need to protect against bribery because we don't want anything like what happened with Louis XIV and Charles II. The example he gave of bribery was accepting actual money as the head of state. So what had happened in that example that Morris gave as his example of bribery was that Louis XIV, who was a bit of a recidivist when it came to bribes, gave Charles II a huge amount of money, as well as other benefits, including apparently a French mistress, in exchange for the secret treaty of Dover of 1670. It also was in exchange for his converting to Catholicism. But that wasn't some broad notion of bribery. It was actually quite narrow. So I don't think that dog will hunt in the 18th century, and I don't think it'll hunt today. Because if you take a look at the 21st century, bribery is well defined. And you shouldn't just take our word for it. You should look to how it's defined by the United States Supreme Court. In a case called McDonald versus the United States, the Supreme Court looked at a public corruption bribery case. This was a case where gifts were actually received, benefits were actually extended. There was completion. This was not some hypothetical of a crime that was not fulfilled or an action that was not actually taken. The Supreme Court unanimously overturned that conviction. Unanimously. And what they said was that you cannot take the bribery crime and use what they called a boundless interpretation. All the justices said that it's a dangerous thing to take a crime like bribery and apply a boundless interpretation. They rejected the notion, for example, that bribery could be used in terms of setting up meetings and other types of things that occur in the course of a public service career. So what I would caution the committee is that these crimes have meaning. It gives me no joy to disagree with my colleagues here. And I really don't have a dog in this fight. But you can't accuse a president of bribery. And then when some of us note that the Supreme Court has rejected your type of boundless interpretation, say, well, it's just impeachment. We really don't have to prove the elements. That's a favorite mantra that is sort of close enough for jazz. Well, This isn't improvisational jazz. Close enough is not good enough. If you're going to accuse a president of bribery, you need to make it stick, because you're trying to remove a duly elected president of the United States. Now, it's unfair to accuse someone of a crime, and when others say, well, those interpretations you're using to define the crime are not valid, and to say they don't have to be valid, because this is impeachment. That has not been the standard historically. My testimony lays out the criminal allegations in the previous impeachments. Those were not just proven crimes, they were accepted crimes. That is, even the Democrats on the Judiciary Committee agreed that Bill Clinton had committed perjury. That's on the record, and a federal judge later said it was perjury. In the case of Nixon, the crimes were established. No one seriously disagreed with those crimes. Now, Johnson's the outlier because Johnson was a trapdoor crime. They basically created a crime knowing that Johnson wanted to replace Secretary of War Stanton. And Johnson did, because they had serious trouble in the cabinet. So they created a trapdoor crime, waited for him to fire the Secretary of War, and then they impeached him. But there's no question he committed the crime, it's just the underlying statute was unconstitutional. So I would caution you not only about bribery, but also obstruction. I'm sorry, Ranking Member, you?
No, you're doing a good job. Go ahead.
Yeah. I'd also caution you about obstruction. Obstruction is a crime also with meaning. It has elements. It has controlling case authority. The record does not establish obstruction in this case. That is, what my esteemed colleague said was certainly true. If you accept all of their presumptions, it would be obstruction. But impeachments have to be based on proof, not presumptions. That's the problem when you move towards impeachment on this abbreviated schedule that has not been explained to me. Why you want to set the record for the fastest impeachment. Fast is not good for impeachment. Narrow, fast impeachments have failed. Just ask Johnson. So the obstruction issue is an example of this problem. And here's my concern. The theory being put forward is that President Trump obstructed Congress by not turning over material requested by the committee. And citations have been made to the third article of the Nixon impeachment. Now, first of all, I want to confess, I've been a critic of the third article of the Nixon impeachment my whole life. My hair catches on fire every time someone mentions the third article. Why? Because you would be replicating one of the worst articles written on impeachment. Here's the reason why. Peter Rodino's position as chairman of Judiciary was that Congress alone decides what information may be given to it. Alone. His position was that the courts have no role in this. And so, by that theory, any refusal by a president based on executive privilege or immunities would be the basis of impeachment. That is essentially the theory that's being replicated today. President Trump has gone to Congress, to the courts. He's allowed to do that. We have 3 branches, not 2. I happen to agree with some of your criticism about President Trump, including that earlier quote where my colleagues talked about his saying that there's this Article 2, and he gives this overriding interpretation. I share that criticism. You're doing the same thing with Article 1. You're saying Article 1 gives us complete authority that when we demand information from another branch, it must be turned over or we'll impeach you in record time. Now, making that worse is that you have such a short investigation. It's a perfect storm. You set an incredibly short period, demand a huge amount of information, and when the president goes to court, you then impeach him. Now, does that track with what you've heard about impeachment? Does that track with the rule of law that we talked about? So, on obstruction, I would encourage you to think about this. In Nixon, it did go to the courts, and Nixon lost. And that was the reason Nixon resigned. He resigned a few days after the Supreme Court ruled against him in that critical case. But in that case, the court recognized there are executive privilege arguments that can be made. It didn't say, you had no right coming to us, don't darken our doorstep again. It said, we've heard your arguments, we've heard Congress's arguments, and you know what? You lose. Turn over the material to Congress. You know what that did for the judiciary is it gave this body legitimacy. It wasn't the Rodino extreme position that only you decide what information can be produced. Now, recently there's some rulings against President Trump, including a ruling involving Don McGahn. Mr. Chairman, I testified in front of you a few months ago, and if you recall, we had an exchange, and I encouraged you to bring those actions. And I said I thought you would win, and you did. And I think it was an important win for this committee, because I don't agree with President Trump's argument in that case. But that's an example of what can happen if you actually subpoena witnesses and go to court. Then you have an obstruction case, because the court issues an order, and unless they stay that order by a higher court, you have obstruction. But I can't emphasize this enough, and I'll say it just one more time. If you impeach a president, if you make a high crime and misdemeanor out of going to the courts, it is an abuse of power. It's your abuse of power. You're doing precisely what you're criticizing the president for doing. We have a third branch that deals with conflicts of the other two branches. And what comes out of there and what you do with it is the very definition of legitimacy.
Let's continue on. Let's unpack what you've been talking about. First of all, the McDonald case, how was that decided? Was that a very split court? Were they really torn about that? That case came out how?
Yeah, it came out unanimous. So did a couple of the other cases I cite in my testimony, which also refute these criminal theories.
One of the things that you said also, and I think could be summed up, and I use it sometimes, just what's the layman's language here, is facts don't matter. And that's what I heard a lot of in the 45 minutes. Well, the facts said this, or the facts are disputed this, but if this, if that, if this, it rises to an impeachment level. And that was sort of what you're saying, that crimes, I think your word was, crimes have meanings. And I think this is the concern that I have. Is there a concern that if we just say that facts don't matter, that we're also, as you've said, abusing our power as we go forward here and literally looking at what people would actually deem as an impeachable offense?
I think so, and part of the problem is that to bring a couple of these articles, you have to contradict the position of President Obama. President Obama withheld evidence from Congress in Fast and Furious, an investigation, a rather moronic program, that led to the death of a federal agent. President Obama gave a sweeping argument that he was not only not going to give evidence to this body, but that a court had absolutely no role in determining whether he could withhold the evidence.
Mr. I have a question on that. Because you brought up Mr. Obama, you brought up other presidents in this process. Is there not an obligation by the office of the president, we'll just use that term not to be Obama, Trump, Clinton, anyway, isn't there an obligation by the president to actually assert the constitutional privileges or authorities that have been given or when accused of something, or crime or anything else?
Yeah, I think that President Obama has invoked too broadly. But on the other hand, he has actually released a lot of information. I've been friends with Bill Barr for a long time. We disagree on executive privilege. I'm a Madisonian scholar. I tend to favor Congress in disputes. And he is the inverse. His natural default is Article 2. My natural default is Article 1. But he actually has released more privileged information than any Attorney General in my lifetime, including the Mueller report. These transcripts of these calls would be core executive privilege material. There's no question about that.
And I think that's something that's, again, not pointed out when you're doing a back and forth like we're doing. The transcript of the call release, the things that have been released from Mueller, as we go back through this, there has been, work in progress by this administration. I think the interesting point that I want to talk about is two things. Number one, Congress's abuse of its own power, which has not been discussed here, even internally. where we have had committees not willing to let members see transcripts, not being willing to